This is the story of two farmers who feel they've been failed not only by the council, but by the entire justice system.
Our farming future is over. My son that was working with me, he's got to take a different line in life.
Melvyn Eveleigh used to be the largest producer of potatoes and onions in the region. Now he's lost almost everything he's worked his whole life for.
Well, we would intended to retire here, and Claudia established all the gardens, and my wife, and she's finding it very hard to be uprooted and moved.
The night of February 16th, 2004, the Manawatu River was swollen after heavy rain and a spillway had been opened to relieve it, but the stop bank breached, causing a torrent of water to flood the area. Over the next couple of days, Mr. Eveleigh and his neighbour Ian Easton lost over $2 million in crops.
We just couldn't believe it, you know. And then just to make it worse was that then it stayed there for weeks because they had to get it all back out again. And it was just unbelievable.
What would normally come next is a sad story of the farmers having to count their losses and move on. But this story was far from over. How much of it do you feel is Horizons Council's fault?
Percentage-wise, more than 100. It's just ridiculous, because not only was it the problem which we believe they caused, but we put a huge effort, and it was simple. We had it under control. We had the water stopped. It had no effect on nobody, and there's no reason why. They just stopped us from doing it.
What Horizons Council stopped them from doing was creating their own stop bank to protect their farms, after it had originally given them permission to do so. It told the farmers the rising water could have affected someone else if they built the stop bank, but couldn't tell them who. The farmers maintain there's no one else it could have affected, apart from a Landcorp farm that was already flooded.
It's only a very short distance here that the road is low here.
So if you built this bank, you think you could have saved your crops?
Yes, it was saved. Even if we had even if it wasn't big enough in hindsight, we didn't know that, but we would have stopped a huge amount of water going across.
We asked Horizons Council why it stopped the farmers from building the stop bank, but it refused to tell us. This wasn't the main bone of contention the farmers had with Horizons. They say the council's negligence in maintaining the stop bank caused it to breach, which resulted in the loss of their crops. And it all comes down to this Whirukino trestle bridge. You see, the council is responsible for maintaining the stop banks of a flood control scheme, which diverts water from the Manawatu River and alleviates it when the river's too high. But the water breached right here under the bridge. As you can see, it's sealed watertight here between the top of the stop bank and the bottom of the trestle bridge. But on that night 9 years ago, the night that Ian and Melvyn's livelihoods were washed away, there were only concrete sacks here and a 15-centimetre gap between the sacks and the bottom of the trestle bridge for the water to get through. The council commissioned a report immediately after the flood called the Sutherland Report. It consulted engineers, council staff and several eyewitnesses. The report concluded the most likely scenario was that the breach started through the gap between the concrete bags and the bridge, exploiting any weakness between the bridge and the stop bank, and scouring it away, letting more and more water through. This scenario explained the flooding observed and matched, in large part, the eyewitness accounts. For the next 6 years, the farmers tried to go into mediation with the council, but in vain.
Every time we would ask for mediation, we'd get close to it, not available. Not available this year, we've got a lot of cases on. We got them right down, one time we got them right down to within a week. And then suddenly, sorry, Mr. Heaney comes back, sorry, we've got an important case I didn't know I had to do, and that was put off. Lost another year. So it was just stalling and stalling.
The council's lawyers did eventually meet with them, a month before the case was due to be heard in the High Court. It wasn't the mediation session the two farmers were expecting.
If we paid them $60,000, they would not pursue us.
So they said?
If we had to pay them $60,000 and cancel the case now, or they will pursue us for everything we've got.
What ensued in the following 10 days saw Horizons Council change its tact to avoid liability. The Horizons engineer had accepted prior to the court case that the scouring started under the bridge, but Horizons lawyers proposed a new theory that it started downstream of the bridge and was caused by cabling. However, this didn't wear with the judge and that theory was thrown out of court. Horizons lawyers finally settled on the theory of an Auckland engineer who hadn't been involved until the court case, who said that the scouring was caused by the interaction between the bridge and the stop bank and had nothing to do with the concrete sacks or any other deficiency attributable to the council. The farmers had the Sutherland report, the engineer who investigated the breach at the bridge, and 5 eyewitnesses that backed up their theory of the concrete bags and the gap causing the breach, and they never changed their story as to what happened. But to the farmers' surprise, although Horizons Council was found to be negligent for failing to repair the gap under the bridge, they were awarded no compensation. In fact, they were ordered to pay Horizons court costs of over $200,000.
Well, it was unbelievable, I thought, because through the case we were given the impression that we were being successful, and at the final judgment it was switched right round.
If it's not maintained and you've been found negligent for it, doesn't that say there must be something wrong there? So then you've got to turn around and pay all their costs for proving that they're negligent. That was just, you know, that was a bigger public kick in the guts than losing the case. They've always said, yes, this is what's happened. Yes, this is what happened, and won't happen again, and this will happen. And you come to the court case and they said, none of that happened at all now. We've got another expert that's going to come and say, this is what happened now, and the court believe it.
No, I don't accept it. I don't think there's any evidence for it. I think it's pretty clear what happened. There was a gap, the water could get out. We know it went out under the bridge first, it was seen.
Gary Williams is a river engineer in the region and was responsible for investigating the breach for the Sutherland report. He interviewed all of the eyewitnesses involved and says he couldn't believe the decision.
So I know that there was leakages around the sandbags, and therefore why look for something else? I mean, it's quite clear that that can trigger the whole failure. There's no need to look for any other possibilities. Sure, it takes place around the bridge, but there has to be an initial opening, an initial way that the water can get out so it can start to bleed out, start to go faster, start to erode it away. So there has to be some sort of gap, some sort of opening.
Convinced they'd been hard done by, the pair decided to appeal the decision and introduce new evidence from Gary Williams that was denied in the High Court hearing. But in the meantime came bad news from ANZ Bank and the harsh reality of their situation.
The bank pressure come, they just wouldn't wait for the appeal. They were not interested in helping at all.
Mr. Eveleigh, who was unable to sell any of his crops that year and crippled by court costs, had his farm put into receivership. His house, farm and machinery were all sold for a fraction of what they were worth. Things got considerably more difficult for Ian Easton as well. When Horizons found out an appeal date had been set, Mr. Easton says it started playing dirty. The pair had to pay $216,000 of Horizons' legal costs before the appeal could be heard. So Mr. Eveleigh's receivers paid his half, and Ian Easton later paid his. A week out from the appeal, however, Mr. Easton says he got a nasty surprise.
They served notice on me, on my company, for $216,000, that I had to pay $216,000. Otherwise they're going to wind me up.
He received a letter from the court saying Eastern Agriculture would be put into liquidation unless he paid the money in the next 5 working days.
Horizons, we went back to Horizons and said, you've been paid your money. You've given us notification you've paid the money. They say, oh no, you now owe us $4,500 of interest on that amount due to from way back. So we're going to change that over from that $216,000 wind-up order. We're going to put that as $4,500. So we said you can't do that. So wholly illegal. So they came back with another deal, was that if we paid them $9,000 plus $2,500 of their costs, they would withdraw this wind-up order. The court didn't advertise it. They threw it out. They came back again, Horizons, over this $4,000. We went back to court again, and in the end, we got awarded costs.
It emerged that the council had put the liquidation request into the court after confirming they had received his money. The timing of all this seems much more than just a coincidence to Mr. Easton.
Well, it seems to be a convenient mistake at timing when you're right in the middle of appeal. It was just another bully tactic, we believe. That would have ruined the appeal for us if they'd pulled that off, and they made a big effort to try and pull that off.
The Court of Appeal, December of last year, and the farmers' lawyer John Upton QC presented their case tirelessly before 3 Court of Appeal judges. The farmers and their families went home for Christmas and awaited the news. But after months of deliberating, the Court of Appeal came back with a devastating decision. The farmers couldn't add additional evidence and the appeal was dismissed. What kind of impact did that have on you?
Huge, huge, absolute huge. We knew it was a nail in the coffin, we always knew that, but you normally like to see reason for why you lose. And there was no reason why we lost.
The council agreed with the Sutherland report. They were the ones who employed the Sutherland report to come and look over the damage, and they agreed with their findings, but through the court case, they discarded it and went down another line that was totally irrelevant.
The High Court ruled against you, the Court of Appeal ruled against you. Do you think there's a possibility you've got it wrong, or do you still maintain that you have it right?
We feel they've got it wrong, and wrong in the aspect is that the evidence is that it seems they've relied on evidence that's been convenient. And when you talk about that Southern report, that backs up what we've always said. It was backed up what the council have always said. But suddenly they all said no. They changed all their mind and came up with a totally different story of what happened here, and got away with it.
It's a legal system. It's not really a justice system. It's about the law, and it's about how you can sort of not pay damages by finding some way in the law not to. That's how I see it. And again, I don't think it's the right way of assessing these sort of cases.
To date, the pair have spent $720,000 on legal fees, on top of losing the $2.5 million of crops. Horizons Council declined an interview with us, saying it wouldn't comment on a case before the courts. When we approached them after the decision, it again declined, saying it would issue a statement, but then failed to do so. Gary Williams, who didn't want to be dragged into this at first, has found himself become more and more absorbed in the case. He says the question he wants answered is why matters of this kind aren't decided by an experienced tribunal, rather than by judges with little or no engineering knowledge.
I just are concerned that a case like this, which is involving natural processes, quite complex situation going on with the stop bank failure, conflicting engineering evidence about what may have caused it and what didn't, that we have a judge sitting by himself to try and assess and understand and make some decision over that information.
I spoke to law professors in Auckland and Wellington about the case, and some interesting points were raised. It's unusual that the plaintiffs, that's the farmers in this case, would not be awarded compensation if the defendant, that's Horizons, was found to have been negligent. it's even more unusual that the defendant, Horizons, would seek and then be awarded costs. It is worth noting, however, that in most other Western countries, councils can't be held responsible for the effects of natural disasters. At the end of the day, it's the ratepayers in the region that are forking out and compensating those affected. Councils around the country were watching the case with interest because if the farmers won, it would set a precedent, and that could be used as case law in future claims against councils. Horizons lawyers themselves told the judge in the High Court that if the farmers won, it would, quote, open the floodgates of litigation against them. Did the High Court judge and then the Court of Appeal judges have these matters in mind when they were deciding the case? Were they wary of setting a precedent? Were they wary of burdening ratepayers, both now and in the future? These are questions we'll more than likely never find out the answers to. If you had the chance, would you do this all over again?
Yes, I would. Yes, I believe that our case was strong, and we based it on fact. We based it on what everyone else was saying, and we were bullied, and I don't think people should get bullied. I don't think you should get put off because you get bullied. I think you should always stand up. Don't let pressure put you off, standing up.